front of him or her at the beginning of a trial, whether they have any contacts or connections that might cause a person of a reasonable, knowledge and background to raise a question.
Why is that important?
Well, it's extremely important so folks, both sides will have confidence in the fairness. The public will have confidence in the fairness of the rulings coming out of the judge, that the judge will not be influenced by something extraneous, such as his personal feelings toward one side or the other. But the judge should never let that influence him. I think a perfect example of how honest and forthright it was in the other big Scrushy case here in Birmingham.
This was the one that was about 2 years ago.
Right. Karen Baldry, at the beginning of that trial,
who was a presiding judge.
Who was a presiding judge, said to the litigants and said to the U.S. attorney, said, I don't know Scrushy personally, but I think I did ride horses one time with one of his daughters. And, if that's a problem, please let me know. I might recuse myself.
Now, that was more or less not to give Richard Scrushy information in case he might want to ask for her recusal,
right,
but give the government.
Give the U.S. Attorney's Office the same information.
I guess the principle there is that not only is the defendant entitled to a fair trial, but so is the prosecution.
Absolutely.
And I'll give
Both
you
sides.
this information if you think I ought to step down.
Both sides are entitled to it. And this motion and brief that was filed by Richard Scrushy's attorneys in federal court in Montgomery, and I assure you I'm not one of those attorneys, but they pointed out a lot of things from public record that reflected what they felt were conflicts on the part of Judge Fuller, showing that from his own financial disclosure forms that he owns a lot of stock in a company called Doss of Alabama.
Now, so judges are required to make financial disclosures about what their holdings are?
They are. And so what information they attached to the motion was motion that the judge himself had disclosed as public record. And so it's not like, this is something that shouldn't have been mentioned. I mean, the judge himself disclosed it in financial disclosure forms, but these were forms that Scrushy and his attorneys had not seen until well after the trial was over.
So they couldn't have made your point there is that they couldn't have made the motion at the beginning of the trial. They found out later on.
That's exactly right. And it shows where Judge Fuller's financial disclosure form showed that he had stock in Doss of Alabama with a receipt of income between $100,000 and $1 million during the year 2004. 2005 says the same thing, receipt of distributions for Doss of Alabama between $100,000 and $1 million. It's interesting that for the whole military contracts that Doss Aviation, Inc. has had, of which Judge Fuller is a controlling stockholder. I know in a Maine report that was filed in 2003 showed himself as a 43.75% stockholder, and I understand it's now been reduced to about a third, but even a third as a whole lot of a company that has done, according to disclosure forms, as much as $258 million worth of business in government military contracts since its inception.
Okay, so if we're connecting the dots to this, it's not improper for a judge to have financial interest within a corporation,
no, it's not.
But connecting the dots, it would impact
but
this
he should
case.
have. What we're saying is he should have disclosed it, should have revealed it, should have given Scrushy and his attorneys a chance to consider it as to whether or not this would be a factor that they would feel uncomfortable with, and should have asked him to recuse himself. And he did not disclose it, and has since then apparently ruled that it was filed too late, but it was, they didn't know about it until well after the trial, and also said that it would influence him, but to a reasonable person out there in the public, you'd have to have a big question mark in your mind about somebody that has done a lot of business, not just with the government military, but also with the FBI. And the FBI is one of the arms of the U.S. Attorney's Office that helps him pursue cases. And
and the FBI did play a part in this Scrushy Siegelman case.
Very much.
Because they did the investigation.
Very much so.
Part of the investigation.
Absolutely. And, it's just not right. A reasonable person would have to have serious questions in their mind about a judge, whether he could be fair to a party when he's doing a lot of business, making money with one party. And again, I say this respectfully to Judge Fuller because he says, this doesn't influence me, And, some people say you just need to take him at his word, but on the other hand, it just raises serious questions when one party, the United States government, has so much business with Judge Fuller, and particularly which is part of the prosecution. The FBI is the arm of the U.S. Attorney's Office. Is it purely coincidental that he's the most pro-prosecution judge I've ever run into? I don't think so. One wonders. Again, He tries to be fair and respectful, and I think he generally is in his rulings, but it's overwhelmingly pro-prosecution. And when you see what they've filed here, then you can only wonder why.
Now, Julian, he denied this motion.
Yes,
what happens next? What will what do you anticipate that the Siegelman and Scrushy team will do next with this denial?
Well, I haven't talked specifically with Governor Siegelman about this, although I did speak to him briefly yesterday. But I did talk with Mr. Scrushy, and he says his attorneys haven't decided yet whether they're going to just plain appeal this to the 11th Circuit or whether they may file some petition for writ of mandamus.
And which is, writ of mandamus is a big legal Latin term, and which basically means?
It's a petition challenging the judge's order or the wrong ruling, and they would have to probably file it at the district court level first as a procedural matter, probably in the same court where the judge has already denied it, and I'm sure he would deny it again, and then appeal it on up to the 11th Circuit. The petition for writ of mandamus, 11th Circuit being in Atlanta. It's the highest appellate body that you can have short of the U.S. Supreme Court itself.